My name is Joe Pereles, and I'm a mediator and arbitrator with JAMS. I've been practicing law for over 45 years, in-house for 29 of those years, in a hospitality environment, and in that regard, spent a lot of time handling development work, premises liability issues, corporate finance, corporate governance, anything that has to do with real estate. There's a quote by a great author by the name of Stephen Covey that says, "Seek first to understand." And that really describes my mediation style. I want to understand the facts. I want to understand why the parties have gotten to this point of an impasse between themselves. I want to understand the emotions that are involved so that I, as a trusted third party, can try to come up with a resolution that allows the parties at the end of the day to resolve a case that has been festering for quite a period of time. I think the characteristics that make for a good arbitrator are keeping an open mind, reading all the materials, and it's important for you not to have any independent research done as you would in a mediation. You want to read the cases, you want to listen to the facts, and come up with a fair decision based upon what you've heard. The most important thing for the parties to do in connection with an arbitration is to really follow the scheduling orders, understand them, and try to resolve as many issues as they can among themselves without getting the arbitrators involved. And then when it comes time to the actual arbitration hearing, be concise and only bring up relevant issues that will help the arbitrators reach a fair decision. I spent 45 years practicing real estate and corporate law. Of that time, 29 was spent in a hospitality environment, but it still gave me the opportunity to do real estate work, zoning work, disposition, leasing, and corporate governance work. Some of the most challenging aspects of mediating are when the parties don't understand what's at stake. I try to explain to them why it's so important to try to resolve the case when they have control over the situation. Because if they don't, even though they think they've got a great position, a judge or a jury may not agree, and that's why it's so important to try to keep an open mind to resolve a case during the mediation. The reward for a successful resolution in an ADR dispute is to end the day with the parties agreeing on something that they may not have thought was possible, that is, a settlement, and letting them control the outcome of the case as opposed to a judge or a jury. When that happens, it's a good day.